going to present to you 5 things you should know before filing a petition for an injunction. The first thing that you should know is how relationships are defined in terms of domestic violence. It's important to understand how your relationship with the opposing party or the respondent could affect the type of injunction that you file. The types of injunctions include domestic violence, dating violence, sexual violence, stalking, and repeat violence. Today, we're going to focus on domestic violence injunctions. The law defines a domestic relationship as individuals who are related by blood or marriage, who are residing together as a family unit, and an unmarried couple who have children in common but are not living together. An example includes if you were in a relationship with someone and you were living together for 8 months, then you decided to separate after the other party struck you in the face. Now the other party, the respondent, is calling you nonstop, is showing up at your home uninvited, going to your place of work. These actions are causing you to have sleepless nights, a loss of appetite, and severe anxiety. Most people would be tempted to file their petition under stalking, because that's what it sounds like would be the most appropriate one. However, the most appropriate type of injunction in this situation would be domestic violence, because the couple once resided together as a family, and stalking is included under domestic violence injunctions. So it's important to understand how your relationship with the other party can affect the type of injunction that you should file. The second thing that's important to understand is the process. The initial process after filing your petition for injunction is ex parte. That means that the judge will review your petition without hearing from the respondent or the other party. The judge will then make a decision. Your petition may be denied for insufficient evidence. Your petition may have an order setting a hearing on it if the judge feels that he wants to hear what you have to say, and you may be given the opportunity to present more evidence in hopes of getting a temporary injunction. The third option is that you may have a temporary injunction. The court may review your initial petition and decide that you should be awarded a temporary injunction. Then you'll be set for a hearing within 15 days of filing that petition. The third thing to understand and to know about injunctions is the type of witnesses that you should bring with you to court. Witnesses for domestic violence proceedings should include individuals who've seen the incident, have witnessed the respondent or the other party be violent or aggressive towards you. Witnesses who will come in to talk about your character as a parent or whether or not you're a good friend are not necessarily appropriate for domestic violence injunctions hearings. The fourth thing to understand is evidence, the type of evidence that you want to bring with you for a final evidentiary hearing. If you're bringing photos of injuries, for instance, you want to make sure that you have physical copies of these photos to leave with the court. Don't show the judge pictures on your phone or a device because you would need to leave that device with the court, and chances are you probably don't want to leave your phone behind. The fifth thing that you should know about injunctions is that you cannot violate an injunction if you're the petitioner. We don't recommend that you would ever reach out or contact the respondent under any circumstances unless ordered by the judge. But people often confuse the fact that you're the petitioner, you cannot violate an injunction once one has been granted. And that concludes my portion of the presentation for Domestic Violence Awareness Month. I'm going to pass it over to Carol Nunez, who will talk to you about family law and the impact of domestic violence on family law cases. Carol, I think you have to unmute.
Thank you, Ananda. Hello, everybody. I'm Attorney Nunez with Coast to Coast Legal Aid of South Florida. I'm here today to impart some wisdom concerning custody disputes when you've had a domestic violence case and a restraining order has been in place. Okay. My first recommendation is to document your interactions truthfully. Usually with a restraining order, you may have been ordered to have no contact except through a co-parenting app. Do not escalate drama or drag out the conflict. Communicate politely and demand the same. Keep things about the children. Also, in tandem with this, if you have an order requiring a co-parenting app, when you go to the family law side and you have a separate family law case, Make sure that when you draw up a new parenting plan, that you continue having that protection in place and that you continue having that co-parenting app being used, especially if you're considering dismissing your restraining order. Okay. My second recommendation is to be aware that it's two separate cases. Okay. The domestic violence case is one case and the family law case is a separate case. Sometimes they communicate with each other. They obviously have the same parties. They have the same children involved, but sometimes the domestic violence has nothing to do with the children. Maybe the violence happened outside of the children's presence. So keep that in mind and know that they are separate cases. If the incident for the domestic violence happened in another county, you want to make sure you have a certified copy of that order. Make sure the court in your family law case is aware that there is this other order out there. Usually, if it's in the same county, you do want to also make sure that it's in your notice of related cases, whether it's outside of the county or inside of the county. You want to make sure that that the court is aware that there is that domestic violence case. Even if it's an old domestic violence case from the past, you also want to disclose that to the court because it could help your custody situation. Okay. My other recommendation for you is to be prepared eventually that the adverse party is going to have time sharing with your children, whether that's in a safe environment through supervised contact or eventually unsupervised contact. Just have that expectation. Be prepared by going through what's called the best interest of the child. That's Florida Statute 6113. It lists specifics what the court is going to look at in determining what is the best time sharing schedule for your family. Okay. If needed, get professional help. There are court interventions that can help you with this. One such intervention is a parenting coordinator, or if you feel the needs of your children or they need representation, you can ask for a guardian ad litem. Also seek help for yourself and your children during this time. If therapy is very beneficial when you're going through this type of conflict. Okay. And my last tidbit of advice would be focus on gathering evidence. Okay. Even if you end up with legal representation, you still want to be able to go through and gather your own evidence. It's going to cost more to have an attorney do it. And they're not cheap. So you definitely want to make sure that your legal team is prepared. You want to, if there are arrest records in the history, you want to get copies of that. If there are other county records regarding other DV incidents, you want to make sure you get certified copies of those. And just going back to what Ananda said for injunctions, the same rule applies. If you have text messages, take screenshots. If you have a co-parenting report, print it out. You want to make sure you have all this for the court outside of in your own device, because you do not want to leave your device with the judge. Okay. And that's pretty much covers all of my tips. Next, we will have Paul from our unit speak to what happens when a criminal case is also involved.
Hi, everyone. My name is Paul Yoon. I'm a staff attorney here at Coast to Coast Legal Aid of South Florida. And what I do here primarily is I represent victims of intimate partner or domestic violence in criminal court cases. And I also assist victims in filing and representing them in injunction cases. So I'm going to provide briefly here 5 tips regarding the criminal case, its interaction with both potentially an injunction case that Ms. Broward talked about, and also a family law case that Ms. Nunez talked about. So first thing my first tip is this, and because oftentimes when you are a victim of domestic violence, there's so many moving parts, there's so many different things that are going on. And I want to help make a distinction between the injunction case and the criminal case. When you file a petition for an injunction, that is strictly about you, the victim's protection through a civil court proceeding, your protection. In a criminal case, it's about the defendant's punishment. So oftentimes, us attorneys here at Coast to Coast will get an applicant who is seeking assistance with an injunction, but because of that incident, let's say the defendant was arrested too. So two cases can be born out of one single incident. And it's important that you understand the distinction, because oftentimes when we speak to our clients, they're confused about, okay, what the criminal case this and the injunction case that. Just be aware that the injunction is about your punishment. The criminal case is about the defendant's, the injunction is about your protection, and the criminal case is about the defendant's punishment. So that's the first distinction, my first tip I want to give you, and that'll help compartmentalize some things as you're going through this difficult time in your life. My second tip is about the no contact orders. You're going to hear those two words all around these two cases, two types of cases. No contact in the injunction case, and then no contact in the criminal case. So the distinction the tip I want to give you here is this. An injunction no contact order can last indefinitely. You'll hear the words until further order of the court. That means it can go on indefinitely. However, a criminal no contact order is temporal. It will end at some point, and that's when it ends, when the criminal case ends. So if you have safety concerns beyond what the criminal case, the length of the criminal case may be, it could be 6 months, 18 months, 2 years. And if you feel you need an injunction that'll last longer than that, of course, then file a petition. But that's a distinction there that is very important for you to understand. An injunction can last, not always, but can last indefinitely, but a criminal no contact order will end at some point. So that's my tip number 2. And kind of a side note on that, you may have to deal with this as well. Oftentimes, in an injunction case, which is again about your protection, and a criminal case, which is about the defendant's punishment, they'll have same conditions. For example, in each case, the judge may order a substance abuse evaluation, or in each case, the judge may order a mental health evaluation. Just be mindful that even though each case orders that, they will handle them, the courts will handle those conditions separately themselves. But this does happen. If there's a substance abuse evaluation that's ordered in both cases, the adverse party, if he or she completes that condition, each court may be willing to honor it instead of making the adverse party, the defendant, do a substance abuse evaluation twice. But just be mindful that it'll all kind of feel like it's blending, but each court can issue those kind of specific conditions as part of their case, okay? My third tip, this is to kind of piggyback on what Carol was talking about with family law cases. We're talking about paternity cases. We're talking about divorce cases. So oftentimes I have clients that'll talk to me about their case, and there's kids involved or there's property involved through a divorce. We need the criminal case to do this, Paul. We need the criminal case to do that. And I put them at a full stop and I say, absolutely not. Criminal cases are not ever going to get involved with family law issues. It's not because the judge in the criminal courtroom doesn't care about your kids. It's not because the judge doesn't care about your property and the divorce that you're going through. That's not what it's about. A criminal case is specifically about the defendant's punishment for breaking the law. That's it. So my tip about this is this. If there is a family law case and a criminal case, or the injunction may have some kind of time-sharing condition, the criminal court will defer to the family law court orders because they're not going to get involved. They will defer to, let's say, if the paternity case has a temporary time-sharing plan or a parenting plan, the criminal case will follow that. Why? Because usually in a criminal case, there is some type of no contact provision. Well, what if there's an exception carved out in the family law case that says they're allowed to have contact, that you are allowed to have contact for the care and custody of the minor child? Well, then we can't have two inconsistent court orders. They have to be the same. So to make sure there is no issue, the criminal court will once again say, all right, there's a no contact order here, but if the family law case says that you're allowed to have contact for the care and custody of the minor children, then we will allow and follow that order as well. So that's my third tip. Be mindful of that. Number one, that the criminal case is not going to get involved, but they'll follow any contact conditions in the family law cases. My fourth tip, once again, this is Domestic Violence Awareness Month coming up in October here. Well, we're about in October. You as a victim of domestic violence have specific and very important rights under the Florida Constitution. We call these Marsy's Law, victims' rights, and they were implemented back in January of 2019. These laws, these rights that are on the books for victims of crime, any victim of crime, and of course for domestic violence victims, are helpful in two ways. I'm going to just name a few of them real quick, and you'll see the theme of these rights. The first set of rights are rights that allow a victim of crime to participate in a criminal case. You as a victim should have your voice heard through a criminal proceeding. No doubt about it. So the rights that are given to you is that you have a right to be present at any and all court proceedings involving the criminal case. Not only do you have a right to be there if you want to, you have a right to be heard. Let's say there's a safety concern. Let's say there's an issue with returning to the home to get some belongings, whatever it may be. You have a right to express these concerns to the judge in a court proceeding. Nowadays, after COVID, we have a new normal, especially that's helpful for victims of crime, that they can appear via Zoom. So they don't have to be in the same courtroom as their abuser. That's a very uncomfortable setting. Or you may have kids and it's difficult to get to the courthouse and find childcare. Well, you can appear via Zoom and still exercise your right to be present and a right to be heard. So those are a couple of rights there to help you as a victim participate in a criminal case. There's another subset of rights that are there to help protect a victim of crime. For example, a right to confidentiality of information. What this tries to do is give you the right to make sure that if you relocate to try to get away from the abuser, and you have a new address, or you're going to a shelter, whatever it may be, and you don't want that abuser to know where you are, you have every right under the law to keep that information confidential so that he or she cannot try to locate you, to harass you, or to coerce you, intimidate you into certain things. And that's the other right that I just want to segue into, is that the law says you have a right to be free from any kind of intimidation, coercion, or harassment. Oftentimes, we as attorneys here deal with situations where the defendant is trying to get to the victim, to try to whisper sweet nothings and say, this will never happen again. Just tell the state attorney, drop the case, and I promise this will never happen again. The law wants to make sure that the victim is protected from that kind of coercion. Sometimes it's violent too. Once again, we want to make sure, the law wants to make sure that victims have rights to protect themselves from that. So once again, the fourth tip, you as a victim of domestic violence, you have very important rights in a criminal case. So be mindful of that. Lastly, when we're dealing with criminal cases, domestic violence criminal cases, the ultimate question, the most important question is usually, how is this going to get resolved? What is going to happen to me? What is going to happen to him? Well, here's my tip for that. There are three basic ways to resolve a criminal case. I just basically call these options 1, 2, and 3. The first option is some kind of case dismissal. Sometimes the victim actually wants a case dismissed. The state attorney's office here in Broward County, the 17th Circuit, does a pretty good job of honoring a victim's wishes. That's one way a case could be dismissed. Another way under option number 1 that a case can be dismissed if there's some evidentiary issues. An extreme example of this will be, let's say the victim is making the allegations up. When the state attorney is not going to move forward with the case then in that situation. So option number 1 to resolve a criminal case is a dismissal. But if it doesn't get dismissed, you have to go to option number 2. And this is the most popular option. I say usually, about statistically speaking, about 90 to 92% of criminal cases get resolved with some kind of negotiated plea deal. The key word there is negotiations. That inherently means each side, the defendant and his attorney, the state attorney, and you, the victim, are not going to get everything you want to try to resolve this case. But usually they try to meet in the middle to resolve it with both interests in mind. You may be asking yourself, well, if they make a deal, if they're trying to make some kind of negotiated plea deal, what kind of deals do they make? Well, it's going to be either jail time or probation, but more often than not, it is some level of probation. And that's where the no contact order comes into play as well. Just be mindful that a criminal probation can still have a no contact provision, a stay away provision as an order of probation. And lastly, the last option, if the parties just cannot come to an agreement, the case is most likely going to have to go to trial, and a jury will decide. A jury will decide the fate of the defendant. Either he or she will be found guilty based on the evidence or not guilty. If the defendant is found not guilty, the case is dismissed, and he or she is free to go. If the defendant is found guilty, then he or she will have to face the judge for his or her sentencing. So those are my 5 tips of how a criminal case as a victim of domestic violence in a criminal case can intertwine with the other, with a family law case or an injunction case. So with that being said, I want to thank all of you who have watched this. Here in the next slide, as you see, there's some of our contact information. Please feel free, and we encourage you, I should say, to look at our social media. We have a lot of things that are posted there through our Instagram, Facebook, you name it. It's all there. But most importantly, our website is there on the screen with our direct phone number. We are legal aid here. We are here to help those in the community, all corners of Broward County. So if you have any family law issues, domestic violence issues, things of that nature, please reach out to us and we will certainly see if we can help you. Carol, Ananda, anything you want to add? Or
No, thank you everybody for coming and listening to us.
Thank you very much. Bye-bye.
Okay. Did you
All
stop the
right.
recording?